rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. Good morning. We are here today for argument in CV22-0254, Audit USA versus Maricopa County. As you may know, we record and are currently live streaming these proceedings. So when you rise to speak, please give your name and the name of the party that you represent for the record. If you have a maximum of 20 minutes per side, as is shown on the timekeeper on the podium. You're not required to use all your time, but you are required to keep track of your own time. So if you would like to reserve some time for rebuttal, that is your responsibility to do. We have reviewed your briefing, we've reviewed the record, we have discussed this case this morning in conference, and with that, please proceed.
Yeah, thank you, Judge. I'm Bill Reisner. I represent the appellant, Audit USA. May it please the court. I will try to reserve some time, and I hope I succeed in my responsibility in that regard. I want to mention at first, just because it's something that the people have determined in Arizona, to give a little background for the evaluation of 16625, which was Article 7, Section 7, which provides that in all elections held by the people in the state, the person or persons receiving the highest number of legal votes shall be declared elected. This is the definition of democracy, and it's determined by the people. Maricopa County uses a software system through the Dominion Company that processes ballots, counts votes, and it's an excellent system. We certainly commend Maricopa County for its ability to process votes, to do it accurately, and in this case, we've provided in the record confirmation through Maricopa County itself as to its ability to keep track of each vote, each ballot that is received. They have a system that I think it's said that Dominion claims that its election files are bit level sensitive, that any with regard to accuracy and precision. So we have a situation where the taxpayers, the people of Arizona, have and the county have purchased and have a system that permits them to scan each ballot. Each ballot that is scanned receives a unique number so they can find it later. The system produces in the cast vote record indication as to how each particular ballot was considered, how each vote was interpreted by the software. So we're in a situation where the people overall can feel comfortable that there is a system that is keeping track of each ballot, and that it can be checked and reviewed. So there's no question in this case that the ballots and the ballot images are public record. And what the legislature did with 16625 is pass a protection, we believe a protection statute, and we think that the legislature was aware of the technology and aware of what they were doing. And this statute applies not just to Maricopa County, it would apply to the city of Phoenix or anyone else that's conducting an election.
Let's talk about the language of the statute.
Yes.
So the statute, because that really seems to be the central question for us to grapple with.
No question.
And the statute precludes any unauthorized copying or transfer.
Right.
It seems to me you, and please correct me if I have this incorrect, your argument seems to be any person who can properly put together a public records request has essentially affected an authorized copy process. So the only boundary on what can be copied from these digital files is that a person be competent to put together a public records request. Is that what you're saying?
Well, I suppose in a way, I certainly say that these are public records, that any person could request it. Any person would have to competently do it, be willing to pay the cost of a hard drive or a thumb drive, whatever the medium is for having it copied.
When the statute prohibits unauthorized, that's only a limitation designed to make someone file public records requests as opposed to just walking in and saying, hey, here's a thumb drive, make me some copies?
No, maybe they could do that.
What does unauthorized mean? So the implication is if it's unauthorized copying is prohibited, then authorized copying must be allowed. So what does the authorized copying mean?
The authorized is the...
Who's doing the authorizing?
The county. Whoever's running the election and has control of the data, they are the ones that have to make a copy. So if you look and see what the Maricopa Board of Supervisors did in response to...
So the Maricopa Board of Supervisors, which I think both parties agree is the officer in charge for purposes of this suit, right?
Absolutely.
Okay.
Absolutely.
So then they could just decide to publish it all on a website on their own and say anybody can have access to this, and that would be authorized since they're the officer in charge?
Sure, I think they could do that, absolutely.
But then, doesn't that ignore the last clause in the statute?
No, what's the...
All security measures are at least as protective as those prescribed for paper ballots.
Sure. Well, the protection here for the electronic data is vastly better than the protection for paper ballots.
But don't we presume that the legislature knew that? That they knew that when they adopted this statute? Okay, so but how does that change?
Well,
how does that change your position?
it
I mean, let me give you the example. So let's say the board has in the basement of the county building facilities, there's a lot of boxes, I guess, of paper ballots. Could the board, the officer in charge of elections, could the board say, look, we're going to go ahead and copy all these, and then whoever wants to stop by and pay for those copies, they're all yours. Can the board do that?
Well, I'm not sure I understand your question.
Could the board authorize,
Can
the board give the paper ballots to the public, to anybody who wants to review them?
Well,
Either through a copy or inspection. Can the board do that?
absolutely not.
Why not?
Why not? Because there are regulations concerning paper that have been determined because of the history.
But in the statute says all security measures that are at least as protective as those prescribed for paper ballots. So
Sure.
that's the floor.
Right.
That's the minimum.
Right. I agree. How are paper ballots protected? Paper ballots are taken from wherever that voting location is. Political party representatives go with them. They're taken to a central location to make sure that no one has access to the paper. They are protected at that location to make sure that no one has access, because history has shown that people can go in. They could fill in a bubble that wasn't filled in.
So
They
the
can
statute
alter.
624 says they have to be unopened and unaltered, right?
Exactly, because that's how you protect.
Isn't making a copy, though, wouldn't that require opening it?
No. Well, I don't understand.
Sir, you're not participating in this argument, so I'd appreciate it if you would not participate in the argument.
I'm not sure I understand your question, Judge.
If it says paper ballots have to be locked away
Yeah,
and unopened and unaltered.
yeah.
All right. How are we making a copy if they're not to be opened?
Well, all the ballots are copied when they're cast. They're put through a high-speed scanner. They're all copied, and they have
I know. I was talking about paper ballots. So
paper ballots.
okay, so paper ballots. Now they're in boxes,
Yeah,
locked away.
right.
All right. And you just told us a minute ago that the county could copy them and let anybody have access to the copies.
I said that anybody could have copies to the digital image of those paper ballots.
But the statute 625 says these digital images have to be at same security that is provided for paper ballots.
They have better security than is provided
Right.
for paper ballots.
So if we can't make copies of the paper ballots, how can we make copies of the digital images of those ballots?
Because paper ballots have their own set of rules that have been determined historically by special statutes. We have experience in this country that someone who has access to paper ballots can fudge, make marks, things can happen to paper ballots. So to protect them, we have a certain set of rules. Now we use computers that have an image. It's the image that's counted, and it's the image that's protected. It's protected, as Dominion says, right down to the bit level. Yeah, there's what's it called? You know, there's no way you could get access to that system. So what the statute says, it gives responsibility to whoever runs the election to ensure that it's protected from physical and electronic access. So no one can access that. Just like you can't access the box, you can't open it, you can't get in the warehouse, you can't touch it. Same thing. They have a responsibility to keep the electronic files, those images, totally secure. And the system does that. It's capable of do that. They said that it does that. It does it. There's no question that they have that ability. Then the question is, can someone, if you can't access their computer, how can you change anything? How can there be fraud in an image? If you look at what Senator Griffin said and what was said to the committee, we have concern that someone might manipulate, make changes, and there might be fraud. And so we want to make sure that these electronic images are protected, just like we have laws that say that the ballot boxes are protected. But the ballot boxes, they're protected, and after 2 years, they're in the custody then of the treasurer, and they're destroyed. You can bet that these electronic images are not sent over to the fire. They're not to be destroyed. It's a different technology, a different setup. But all of it comes back to how can we protect to see that there's no changes? How can we make sure that the images are protected as the paper's protected? It would be insane. In Maricopa County, I think you had something like 1,400 boxes. It's an incredible thing, 2.1 million papers. There's a whole series of things that deal with papers. But technology has changed, and that's what the 1625...
Yeah, but then the legislature said, treat the digital the same as you do the paper. That's what I'm hung up on.
Well, but it says protect them like you protect paper.
Yeah.
That's what when...
Let me, I'm going to tip my poker hand to you a little bit. So I read unauthorized as meaning there's at least some ways in which it can be authorized. I don't read it as broadly as you do to mean that anybody could file a FOIA request for it. And I read unauthorized, the authorized would be in the case of a recount or an election contest. That's where someone could get access to those things. What am I misreading?
Well, you can't get access to them.
So you couldn't get access to them in an election recount or a contest?
Well, in an election...
That's what the 624 provides for paper ballots.
Yeah, but an election contest has to be filed within something like 5 days.
Right.
You have to specifically allege. How are you going to ever be able to say, I want to look at the images and these particular race within 5 days for something that you can't see? You can't do it. And so what
isn't that for the legislature to fix? I don't.
No,
it seems like you're asking us to do something the legislature is forbidden.
No, absolutely I'm not. I'm asking you to recognize that the ballot images are protective, to recognize the importance of votes, that the Constitution says in our democracy that whoever gets the highest votes.
And lawfully cast votes, right.
Lawfully cast votes. How does the people do that? How do we determine that? How does anybody determine that? You can now. Technology has made it so you can, because you could get those ballot images. The Dominion system explains that you can, through computers, you can sift them by race, by areas.
Do you disagree with me that you can't get copies of the paper ballots right now?
Yes, absolutely.
Why isn't that dispositive when the statute says in other words, if you can't get copies of the paper ballots, you can get copies of the digital ballots. That's how I read the end of 625.
Sure, but look, and this is what the state does. They conflate disclosure with protection.
Oh, so you're saying security measures doesn't necessarily equate with disclosure.
Right. Well, what it says here in the law says we want to ensure that it's protected from physical electronic access. And Senator Griffin says, really, this is a protective issue. We want to prevent any fraud or manipulation of those ballots. So the images are protected. You can't access it. So it's up to the county, is up to whoever's running the election to protect the data in their computer.
Okay. You've only got about 2 minutes left if you want to save some for rebuttal.
Okay, I will save some. Thank you, sir.
Good morning, and may it please the court. My name is Joe Branco from the Maricopa County Attorney's Office here on behalf of my client, Maricopa County. Two provisions of Section 16-625A control the outcome of this public records dispute about the release of digital images of ballots from the November 2020 general election. First, Section 16-625A prohibits the unauthorized copying or transfer of digital images of ballots. If Arizona public records law authorizes, really, that means requires, Maricopa County to copy and transfer those digital images of ballots to members of the public in response to a public records request, then this provision is meaningless. Second, Section 16-625A also mandates that Maricopa County take security measures that are at least as protective as those prescribed for paper ballots. Relatedly, Section 16-624A outlines several security features for paper ballots, most notably that paper ballots are to be stored in a package or envelope in a secure facility. That package shall be kept unopened and unaltered. And when the time comes for destroying the paper ballots, the destruction must occur without opening or examining the contents of that package. If Arizona Public Records Law requires Maricopa County to open the digital images of ballots for inspection and examination, whether on-site or remotely, then Section 16-625A's security measures provision is similarly meaningless. And Section 16-624A's requirements regarding paper ballots are superfluous. On appeal as below, appellant raises numerous public policy concerns about why the
Counsel,
digital...
would you agree with me that the statute lacks some clarity? And it could have said, explained what, by saying unauthorized, clearly leaves the implication there is some copying that can be done that's authorized copying, right?
Yes, Your Honor. In fact,
And how are we supposed to know what that range of authorized copying is?
I don't know that we know the range of it, but I don't think that when the legislature drafts a law that they need to account in that specific law for all circumstances in which a particular aspect of
Is it
it.
an unreasonable interpretation to say unauthorized would be pursuant to a public records request?
That would be unreasonable, yes,
Okay.
flatly, because anybody can submit a public records request. You asked, Your Honor, if somebody could show up in the building. They absolutely can. Under Arizona Public Records Law, there's no form you have to fill out. You don't even have to give your name.
Right. So maybe, I'm not saying I agree with you, but we can say that provides at least some kind of parade of horribles or unreasonable interpretation of it to say that. What if there was some type of, not a election contest, but a litigation involving election ballot counting and Dominion's stuff? A subpoena issued by a court, would that be authorized at that point?
Perhaps I could also think of a subpoena issued by a legislature that we had to deal with, in which case our argument there that it wasn't authorized failed in the Superior Court. And so I think that there is a range. I just don't think that Arizona's public records law fits comfortably in there.
And intuitively, I find myself wanting to agree with you on that, but why wouldn't the legislature just say, hey, we're exempting ballots from FOIA, or not FOIA, but public records requests, or alternatively, authorized means pursuant to a X, Y, or Z. Why didn't the legislature say something like that? And why can't we look at their failure to provide those as evidence of ambiguity in the statute, which would then allow us to look at legislative history?
I think that, well, two things on that.
That was the most compound question I've ever asked.
That's all right. I'll give a succinct answer as I can. I think, first of all, it's important to look at the language that the legislature did use, right? So we have unauthorized doesn't precede access. It precedes copying and transfer. I believe what opposing counsel is talking about in terms of things being unauthorized really has more to do, and security measures, has more to do with access. So if Arizona Public Records Law authorized access, I think that would then result in this court applying the canon of statutory interpretation when the law becomes an absurdity. Because for reasons I've already explained, anybody can make a public records request. That isn't a very high hurdle to get over. Getting into authorizing copying and transfer for purposes of a recount or a contest is a higher bar. And so those would be, and I think with the second half of 16-625 referencing how paper ballots are treated, I think that the legislature is pointing this court and elections officials in that direction and saying that's the sort of authority we're looking at. As I said, a year ago, almost 2 years ago at this point, a Superior Court determined that a legislative subpoena would also satisfy. And I would point out, not that it's binding on this court, the Superior Court's order, but I would point out, as we did in the briefing.
Depends on the judge.
Well, I'm not going to ask this panel's opinion on Judge Thomason, but I think that what Judge Thomason pointed out there was when the county raised this exact argument that it wasn't authorized. Authorized means a recount or contest. The Judge Thomason specifically said, well, what we're talking about here is not releasing it to the general public. We're talking about releasing it to the legislature pursuant to a legislative subpoena. And so I think we can all admit we would be better off with the legislature having crafted a more specific statute, one that maybe enumerated what authorized meant, what specific security measures. But I don't think that there's a problem. I don't think it's a problem for the legislature to leave in some wiggle room here, even if it results in a little bit of uncertainty. I think what is certain, however, is that the county would need to copy and transfer these digital images of ballots in order to supply them for a public records request.
Can I,
You go ahead.
just a really technical question, but is there any legal difference in your mind between the words copy and transfer? What you just said both. You said the county would need to copy and transfer.
That's right.
What does that mean?
I think unauthorized copying, I don't think the county, so for instance, under public records law, and we go into this a little bit in the brief, because I think the entire statute is actually at odds with Arizona's public records law. It's not only, we often think of public records law being providing copies for members of the public, but there are some documents that you can come down, or it's the preference of the requester to come down and inspect them.
Available for inspection.
Right, so for instance, we wouldn't, I think the copying, the transfer provision obviously has to do with supplying them on a thumb drive or a hard drive or what have you. It would probably have to be a very big hard drive. And copying would be, you can't just have them at the kiosks the way that the county makes accessible other aspects of databases, in particular with respect to elections. So I think that's where copying or transfer would be.
Your colleague here identified the county Board of Supervisors, as those who do the authorizing. So I guess under this discussion about the public records law, why can't the county then just be tasked with, if somebody comes in and requests that the county has retains the authority to authorize that copying? That seemed to be, I think, what your colleague was arguing. Can you respond to that?
Yes, I think it's that would be an odd interpretation of the statute for the county to authorize itself pursuant to public records law to do it. And in the briefing, we discussed how it would similarly then mean that if the county saw fit to post it on its website, the county could authorize itself to do that as well. For all the public policy reasons that have been raised in this case, I think that that's a very difficult reading of the statute. I think that for two reasons. One is, going back to drafting statutes, I think if the legislature had intended the county to have that power, it should have said so explicitly. We often don't imply powers, particularly for political subdivisions. We look to see if it's explicit. And second of all, I think that it starts to erode that second part of the security measures portion of it. If the county can simply take it upon itself to effectively do an end run around section 16-624.
Well, that sort of takes us to your colleague's other argument that there is a distinction between security measures and disclosure. And there is something there that, perhaps what we're talking about in security measures is in the preservation of the paper ballots as documents, the preservation of the electronic system of retention, but that disclosure is something separate or unique. Can you talk to me about that?
I think that's the first time it's been raised in this appeal. Maybe it's just being articulated differently now. I don't see anything in the statutory scheme that would suggest that the security measures are somehow disentangled from the copying and transferring positions. It's an and in the statute. And even if it was different, the security measures in the preceding statute, 624, it's interesting to me that those clearly are the security measures. And they talk about not just leaving the package or the ballots unaltered. They also talk about, in subsection A, leaving them unopened. And they also talk about, as part of those security measures, that the treasurer is to destroy the package without opening or examining it. And so I think that those are all bound up together. I don't know that the legislature intended for us as elections officials, my clients, to so neatly parse what those security measures are. You put them in boxes, you put them in the vault, and you leave them alone. And that's a very direct command from our legislature. And I think that that's a similarly direct command in 625, that the digital ballot images are to be protected from physical and electronic access. And nothing gives the county the authority to access it itself on its own whims or in response to a public records
So with
request.
digital images, just so we understand this, would you take the position then the digital images would also need to be destroyed in the same time frame? Is it the intention of the county to destroy digital images when the time comes? Just like you would do with, how do you do that? The big shredders? I don't know. I don't know how you do that, but
I'm not sure, maybe flamethrowers. And I'm not sure, frankly, I'm not sure we've reached the outer limits of my knowledge of the cleanup from election administration in terms of what the county does with the digital images of ballots following the 24-month retention period. I would also note that whether
the reason I'm asking that is because if we're saying security measures really apply to both sets of data, the digital and the paper equally, so that there's a floor there, it seems to me that they would have to be destroyed for protection, as a security measure, so that down the road they don't fall into the wrong hands by a password problem or something like that.
Yeah, and I think that's a fair reading of the statute. I don't know that it's been at issue in this litigation. I don't know that it needs to be resolved today. Yes, Your Honor.
Well, finish answering Judge Brown.
No, I was going to say, I think that's a question for another day in terms of how far we need to take that. I think that for today's purposes and for this public records disputes purposes, we've got both provisions, right? So we've got the unauthorized copying or transfer provision, and we also have the security measure provision. I think either one is dispositive, but in particular, I would point to the unauthorized copying or transfer. If the legislature had intended something as ubiquitous as public records requests to serve as authority, then they probably didn't need to write that provision into the statute to begin with.
This is probably beyond the scope of our issues, but since you entertained one from Judge Brown, I'll throw one out too. Why are we fighting so hard over this? If the ballot images are protected down to the bit level that Dominion they can't go and modify those and come back and say, see, these ballots actually were cast a different way, because you guys have the originals and they're crypto protected, I assume, to some level that we could say, no, here's the originals and here's what they show. Why do we care who has access? Why wouldn't it make everybody feel a lot more secure about the validity of elections if we just gave this stuff up?
In terms of the technology, I am an MS-DOS guy in a Web 3.0 world, so I can't speak to that, and it's not in our record, about what harms may befall the public if these digital images are released. I can say, in terms of why are we fighting so hard, it's because the law is the law. I think that we read that 47-word statute pretty clearly as a command not to release this. The legislature may have a better idea about what may happen. And in fact,
you don't disagree that, just when I read in the briefing, that you don't disagree that other jurisdictions, at least some, have started doing exactly what they're asking to do. I mean, they're releasing these images, copies of the images, I guess, to the public.
At this point in the procedural posture of the case, I can't say. This was on a motion to dismiss on whether or not the public records request could clear this initial hurdle. I would point out that if it was remanded, we would seek to develop whether or not, as is our right, we would want to develop whether or not releasing these images is in the best interest of the state. I can think of some hypotheticals, and they may be edge cases. I'm informed, I don't know how reliably, that in the past, when poll workers or elections officials have opened up ballots, in order to count them, people write their name on it. They sign it. You can imagine a vote buying scheme pretty easily that you would then be able to verify that you actually voted for who you said you were. I think that's pretty at the risk of undermining myself if this gets remanded, I think that might be far-fetched. But with technology moving so quickly and our laws struggling to keep up, I think that elections officials are in a better position to apply a bright line rule like that in section 16-625 than trying to do that balancing themselves.
And you discussed this a little bit earlier, too. I think you've answered my question on that part. Were these images all turned over to the legislature and subject to the audit that the legislature conducted?
It is my understanding that the digital images of ballots were turned over to the legislature. What happened after that with the materials that were provided to them, I think, is open to some debate. So I'm not sure exactly what happened to them once they went there, but it is my understanding that there was a clone of these made and they were supplied pursuant to a legislative subpoena. And unless the panel has anything else, we would respectfully request that you affirm the Superior Court's decision dismissing this action.
Thank you, Counsel.
Thank you.
Yes, thank you. Look, the decision on public records as to whether they can be disclosed has been made in Arizona. These are public records. All public records can be disclosed unless the legislature has prevented it from some category, or unless under the Carlson case you can specifically show some harm to the government or something like that. So there's no question that public records should be disclosed in Arizona. It's authorized to disclose them. What this statute talks about is protection. And it turns out that we have technology that protects it. And we have, when Your Honor asked about whether the county had provided these things to the legislature, it's an exhibit in the case, but when the Senate subpoenaed them, and the court says you have to turn it over, the county election department created what they call a clone, and they created a copy for the Senate. They gave it to the Senate. Later, the ninja group, somebody said they had a problem with it, that something wasn't in it, this and that. So the election department went back, took the clone that they had, which was made the same week that we asked for it, and they tested it and said, nope, everything's in there, it's a great system, it's all there. So they have a contract by Dominion that provides that it could be put on the internet if they wanted. They do that in San Francisco, it's in Georgia, it's part of the law this last election in the state of Georgia through efforts of audit.
Thank you, Counsel. We appreciate your arguments. Your time has run. Thank you both
Okay,
for
thank you.
your briefs and your arguments. We will take the matter under advisement and we will issue our decision in due course. Court is adjourned.